You're the appellant, are you not?
Yes.
We're ready for you.
Please, the court. My name is Ray Terpstra. I'm a lawyer from Cedar Rapids, Iowa, representing Community Bank and Trust Co. in this appeal. This case is essentially a case revolving around Section 654.12a of the Iowa Code. The provision reads, essentially, that the amount of the indebtedness secured by a mortgage can be capped at a dollar amount certain. That would include advancements up to that amount, plus interest on that amount. The way other debt is pulled into that cap is by using a dragnet provision in the mortgage, which essentially recites that the mortgage secures not only the debt, but all other debt. And this mortgage does contain a dragnet provision. Unfortunately, the lower court in this case completely ignored the operative effects of Section 654.12a and found that all debt in excess of the $148,000 cap, totaling almost $600,000, was secured by the mortgage, and error was preserved on this issue. Section 654.12a has never previously been interpreted by the Iowa Supreme Court. An issue was discussed in an unpublished Court of Appeals decision titled Wells Fargo Bank N.A. versus Valley Bank and Trust. The date of the case was September 5, 2013, case number 12-2013. Justice Vogel wrote an interesting and well thought out dissent in that case where she did recognize the applicability of Section 654.12a. The majority decision did not reference the statute at all.
So let's assume this mortgage did not have the maximum obligation clause or the notice in it. So we're just dealing, but it did have the dragnet clause. So as I understand it, and correct me if I'm wrong, at that point, the senior lender would have priority with respect to its lien for all funds advanced prior to the time of your client taking a junior interest. Is that right?
Correct, Your Honor.
So as I read this statute, it was intended to protect the senior lien holder with respect to at least the maximum obligation listed in the mortgage for funds advanced after a junior lien comes into place. Is that right?
That's not what the statute says, Your Honor. A plain reading of the statute simply recites that the maximum amount secured shall be the amount stated, plus advancements up to that amount, plus interest. There's no reference to when a subsequent junior mortgage is reported.
Doesn't the statute say that becomes, that the priority of the lien up to the maximum amount stated still maintains a senior interest even though the funds were advanced with actual knowledge of a junior interest?
Up to the maximum cap amount, that would be correct.
I guess why would any lender then put this provision in there if it actually hurts their priority? I mean, the whole point of this is to protect their priority when they extend funds of actual knowledge of junior lien interests. They put this protection in there, and now it's actually hurt their priority with respect to all funds advanced prior to that. That seems backwards to me.
Yeah, that field can be eliminated, and the word unlimited can be used instead of a dollar amount.
Doesn't it also protect the senior lender in this sense? So if in the old days, if you were the senior lien holder, correct me if I'm wrong, and your obligation was paid down and then you learned of a junior lien holder that had extended credit, then anything you did after that was below the junior lien holder if you had actual notice. Isn't that right, under the common law days?
Right. But
And what this does is say, whether, no matter the timing of the extension, you're protected up to the $148,000. You can extend it before, after, whether you have notice of the junior lien holder or not. It fixes it creates certainty. So in that sense, it does protect the senior lien holder, doesn't it?
That's correct, Your Honor. It gives a dollar certain that will always be prior in amount and in priority to any subsequent.
The nature of these transactions is the balances go up and down with these operating loans, kind of what happened in this case, isn't that right?
That's correct, Your Honor.
I talk about some of the cases that you cite, I think, like the Kansas case and Mexico, Utah. All of those statutes have provisions that actually set the maximum amount of the lien as what's stated on the face of the mortgage. And it seems like our statute is different in that it doesn't set a maximum amount. Instead, it just affords priority to funds advanced with actual knowledge, right, up to that maximum amount. That seems very different to me than what our statute does.
Yes, I don't recall the with actual knowledge language being in our statute. It may be.
Can you tell us anything about the history of the statute that supports your position?
I believe it was enacted, Your Honor, to eliminate the uncertainty that existed when a junior mortgagee would analyze taking a second or third or fourth position on real estate previously encumbered by a first or prior mortgage.
I want to take off on that word analyzes. I'm over here. The other side. There you go. Here I am.
Excuse me.
That's okay. You said when you're analyzing it. After that, did your client, when they saw that provision about the I can't remember what it was, the original cap was 148, I believe, and then the actual loans went up to as high as 600,000. Did they look into it? I mean, the paper may have said 148. Was there some diligence by your client to actually look in to see what the loans were? Phone calls? Any kind of investigation?
No, and none is required, Your Honor. The junior mortgagee can rely upon that maximum cap amount recited in the mortgage as evidencing the amount of the secured indebtedness that real estate secures.
Even with that dragnet clause in there, you say there's no requirement, but wouldn't it kind of make sense to do that?
The dragnet provision picks up other advancements up to the cap. So there could be 10 different notes, all secured by that mortgage, as long as the aggregate balances due on those 10 different notes don't exceed the cap. Dragnet clauses are disfavored in this state, are given harsh scrutiny by reviewing courts.
But in spite of that, your client went ahead and did a second mortgage, right?
Right, and the affidavit of Dwight Watkins that was filed in the case indicates that he received information from the borrower that the amount of the secured debt was $140,000. In looking at the Bluegrass mortgage, he realized that the amount of debt secured was $148,000. He anticipated that there was approximately $100,000 in equity, and based upon that perceived equity of $100,000, proceeded to engage in a credit relationship with Mr. Stecker, loaning him additional funds, securing it with that second mortgage, knowing that he was at risk for the first $148,000 plus interest on that amount.
I'm struggling a little bit with this concept that it seems like the general rule is that the junior lien holder always takes its interest is established at the time the lien is created, right? And so to the extent that the senior lien holder has already advanced funds, then that is the best that the junior lien holder can get. I think that's the general rule, right? That whatever the amount of funds actually expended the junior lien holder's priority starts there. Is that right?
Well, except for the plain reading of 654.12a, which caps the maximum amount of indebtedness secured.
So a common law, though, isn't Justice McDowell
Yes.
right? A common law, if you're the senior, if you're the junior lien holder and the senior lien holder knows about you, and the senior lien holder at this point, say, had only $10,000 in debt out there secured by this farm, then the junior lien holder would be able to get priority for everything but the $10,000. The problem with that, I think, in a modern world is that everything jumps around all the time, and you can make phone calls and say how much credit is out there, and the information may be stale, whereas the statute gives you certainty. Isn't that what the legislature was trying to solve?
That's correct, and I believe the statute was passed in 1946. Correct, but its predecessor, I believe, goes back to the late 40s. And a lot of the cases cited in opposing counsel's brief rests on cases that predate the statute, that go back to the common law days, where inquiry, constructive notice, would have led to inquiry by the purported junior mortgagee to the first mortgagee, inquiring as to whether or not there was debt and how much debt there was. But because the debt does go up and down, and there's always the potential for a swearing match as to who said what, as to what that debt was when that phone call was made, or that the loan could be booked later in the afternoon on the same day that the phone call was made, the statute was passed to alleviate or cure that necessity of making inquiry by stating in the mortgage, which the first mortgagee drafts. They control the documentation preparation. They put in the number, and it's a public record. It's recorded, and it's to be relied upon by junior mortgagees in just this type of case where they're evaluating whether or not to make the loan or extend credit to a borrower.
This case be a different case if there was actual knowledge of the size of the senior lien?
I'm not sure, Your Honor, if there would be a different result. I would say no. The amount recited in the mortgage is the amount of the cap. The indebtedness could be $1 million or $2 million, but that particular farm, which was financed for $148,000, probably was put in there because that's all it was worth at that time. That was the amount of the debt incurred to acquire that farm. So I would say, notwithstanding actual knowledge of other indebtedness exceeding that amount, the first mortgagee would be stuck or be confined by the amount of the secured indebtedness recited in the mortgage. The other issue that has come up is whether or not there should be some precedential value given to an unpublished Iowa Court of Appeals decision, the Wells Fargo case, which is cited extensively by both parties in their briefing. That case can easily be distinguished. It does not have to be overruled.
Well, it's not even really, in a sense, a case because it's unpublished.
Correct.
So it's not a precedent. I mean, it's a case for the parties, but it's not a case really for us. Let me ask you the question. If we find in your favor, then we have this issue about the interest rate. And explain to me why it is that Bluegrass, in a few words, why can't Bluegrass just collect 18%?
Because it's not provided in the notes that they're entitled to 18%. There's no default interest provision completed that says the default rate shall be 18%. It states instead that the rate provided in this obligation, in this note, shall be the rate after default. And I think in this case it was 6%. So that should be the rate that governs pre-default and post-default, as it happens in many cases.
But doesn't the don't the promissory notes give the lender the right? It says you may increase the interest rate otherwise payable. Isn't that enough?
But to what amount? 50%? There's a reference to the usury statute which says 5%. So that would be a big ambiguous hole in every loan document where the default interest rate amount is not actually recited, as occurred in this particular case.
You may sum up, Mr. Terpstra.
Thank you.
May it please the court, opposing counsel. I'm Richard Davidson. I represent Bluegrass Savings Bank, which you're probably dying to know where it is. It's 5 miles west of Davenport on the Scott County Muscatine border. This case arises from a 2014 mortgage that has a provision in it that is suggested by Iowa Code Section 654.12a, which was adopted by the legislature in 1984 in a package of amendments that allowed banks to make home equity loans. It was amended again in 1990, where the second sentence, the second sentence that's in the statute now was inserted that says that even if the mortgage balance goes to zero, the mortgage is still valid up to, is still senior to the stated amount.
Mr. Davidson, I agree the core is the statute, so let's focus on the language. The statute says if a prior recorded mortgage contains the notice and identifies the maximum credit available to the borrower, then loans and advances made under the mortgage up to the maximum amount of credit together with interest are senior to indebtedness to other creditors under subsequently recorded mortgages. My concern is you're trying to read that as saying that that language only applies as to new advances after the recording of the subsequent liens. But it doesn't say anything about that in the statute, does it?
Well, what it says in the statute, we believe, Your Honor, is that it is a floor, not a cap. My opponent believes that it's a cap.
Maximum sounds like a cap.
Well, the guaranteed maximum, Your Honor, it guarantees that the senior lender will have priority up to the maximum amount. But that's not the question that we're addressing here. The question we're addressing here is what happens if the senior lender exceeds the maximum amount stated, and what is the priority of that money if it was advanced before the junior mortgage was even in existence?
So to continue that, I mean, the rest of the statute after that talks about the priority of the maximum amount, it says that maintains priority, quote, even though the holder of the prior recorded mortgage has actual notice of indebtedness under a subsequently recorded lien. And that's what you're talking about.
Yes, correct,
right?
Your Honor.
Which
That's the modification to the common law that's made by the statute. The common law was very clear before 1984. The senior mortgage that had a future advance clause was prior up to the point that the senior mortgage lender had actual notice that there was a junior mortgage behind it. Anything it advanced up until it got actual notice was senior and prior to the junior mortgage. There became a question in the legislature's mind, apparently, as to we need to solve this actual notice problem because it's creating uncertainty in the marketplace. When does the senior lender have actual notice? When does the senior lender not have actual notice? So what I'm sorry.
I get that, and it did definitely make that change, and as we discussed with Mr. Terpstra. But why didn't it say if it was to achieve the purpose that you said it achieved? Why didn't it just say loans and advances made under the mortgage after the senior indebtedness is after the junior liens are recorded. Are senior to that indebtedness. Why didn't it have a timing qualification if it was only meant to apply? If the maximum was only meant to apply to post junior lien holder advancement?
Well, I didn't draft it, and it's one sentence, and it's been on the books for 40 years. It's intended, in our view, Your Honor, to solve one problem, and that's the problem of what happens when there's a junior recorded mortgage behind a senior recorded mortgage, and as you pointed out in earlier, and the balance is going up and down, and what is the guaranteed senior priority of the first mortgage? And that's the problem that statute was intended to solve. If there was this up and down of a revolving loan, that advances were made, they were paid back, they were re-advanced, what was the guaranteed maximum that the senior mortgage holder could rely upon, even though there was a junior mortgage that they may or may not know about?
Let's assume this fact pattern then, that you have a junior lien holder who doesn't record, and the senior lien holder never has notice until you get to the point where you're in foreclosure proceedings and it becomes available. I take it your position would be that this statute then really doesn't apply in that context.
That's correct.
Right, because there's no actual notice priority problem, and if you apply it, you've effectively just put a lien cap on the priority lien holder.
Correct. We think that this section was only intended to solve one problem. It's not a lien cap. Our case is common law. This statute, in our view, has nothing to do with our case because all of the bluegrass money had been advanced to the borrower before Community Bank ever loaned $1.
But given the way the statute's worded, isn't it more logical to conclude that the statute was offering protections for both the senior and the junior lien holder? That is, the junior lien holder could look at the 148 number and say, okay, that's the extent of their priority. I don't need to worry about on the day I extend credit to them how much they actually have out there. And the senior lien holder could say, I know I've got this amount of priority regardless of what happens down the road and whether my debt goes up or down temporarily or not.
Certainly, that's the counter argument to our position, and if that is the determination of the court, no bank will ever put a number in that box again less than $50 million. The bank would just put in $50 million, and that would be that, and we'd be right back to the common law on who has priority over advances depending upon when they are made vis-a-vis when the second mortgage is recorded.
Well, what's the bank's incentive now to put anything other than a very, very high number in?
Probably isn't any.
So,
but
again, why is this such a terrible practical concept?
Well, the issue is if the bank hadn't even put that notice in the mortgage, we wouldn't be here. We win. If the bank had simply said that they'd left that section out of the mortgage and the mortgage covers a note for $148,000 plus all other notes and loans and guarantees of every nature that this particular borrower owes to Bluegrass Savings Bank from time to time, and they'd completely left it off, all of that money had been advanced before Community Bank ever recorded its mortgage.
Right. I agree. In this scenario, you're better off. But in the other scenario where your client's loan had been paid down to say $10,000, they'd be worse off.
Your Honor, but I think we're overthinking this situation. I think the statute was intended to cover one very narrow issue, and that is revolving debt, where a senior lender wanted certainty that they had a guaranteed value up to a floor. It was never intended to be a cap to be relied upon by junior lenders. There's nothing in this statute that says, in our view, that the junior lender, it doesn't say the opposite. It says that it guarantees a maximum for the senior lender, but it doesn't say everything above that maximum is junior. I think that opposing counsel is reading the opposite into the statute, and it doesn't say that. It doesn't.
But this would be a different case. So if the funds were advanced over the obligation limit, as identified in the mortgage, after the senior lien holder has actual knowledge of the junior, then the excess would be third in line.
Correct. Absolutely.
Right? But here, when the funds are advanced prior to the junior lien interest, then they all have priority under the common law rule. I think that's what you're saying.
That is what we're saying, is that because this statute triggers a change in the common law under certain very narrow circumstances, and that trigger was never reached in this case because all of these funds were put out there by Bluegrass before Community Bank made its loan. Therefore, we're still under the common law rule of, does the future advance provision in the Bluegrass mortgage make all of its loans senior and superior to the Community Bank loans? And what we believe that the statute does not say is that the over advances, the amounts above the $148,000, are ipso facto junior to the second mortgage. It only talks about the superiority of the rights of the senior lender.
Let's move to the mortgage, which was written in compliance with the statute. In bold print, it says this mortgage secures credit in the amount of $148,000. Loans and advances up to this amount, together with interest, are senior to indebtedness to other creditors under subsequently recorded or filed mortgages and liens. Your position is, in this case, it actually secures credit in the amount of $600,000, right?
Correct, Your Honor, because
that's not what it says.
Two paragraphs below that, it says this mortgage secures all credits and future advances made at any time for any purpose. So what I'm saying here, Your Honor, is the statutory provision, which is at the very top of page 39 of the appendix, and then Section 3B, which is two paragraphs below that, mean two very different things.
All right. Okay. I agree. Later on, there's a definition of secure debts, and I agree that's an open-ended definition. But the definition of secure debts doesn't define priority. The priority is in that bold language, isn't it?
Here's the issue, Your Honor. The bank did not write that language. That's the statutory language, and the purpose of that language.
But that gets back to my point: isn't if what the legislature intended is what's in what seems to be kind of plain language, then why are we doing something different?
Well, because the view we have is that this language triggers the statutory protection. You can't just read this language like it's a contract, because the bank didn't lay awake one night and come up with this language and write it itself. It pulled it right out of the statute and plugged it into its mortgage. Because this language is only used for one purpose, and that is to trigger the protections of 654.12a.
My point is simply, to read the statute as you do, which then requires this language, results in kind of in the mortgages that results in kind of a strange reading of the mortgage, doesn't it?
Honestly, it does, Your Honor. It makes the mortgage ambiguous. The language of the mortgage seems to conflict with itself. But if you look at the broader legal issue of what was the mortgage intended to cover, it's perfectly clear what the mortgage was intended to cover. It was intended to cover all debts. At common law, the bank wins. As out of an abundance of caution, likely, they put the statutory language in above that to trigger the statute in the event that the statute needed to be triggered. The issue here is the statute doesn't need to be triggered because There was no second mortgage when they loaned the additional $350,000. The second mortgage came along 3 years later. So here is Bluegrass Savings Bank saying, oh, we've got a mortgage on this property. We've loaned some additional money. Our mortgage covers all of the debt that we've loaned to this particular borrower. And boom, Community Bank records a mortgage 3 years later, and now what they think is a $500,000 mortgage is now only a $148,000 mortgage. Our view is without a statutory trigger and that very narrow statutory provision that modifies the common law regarding the actual notice issue and the revolving loan that goes up and down, which is not present in our facts, without one of those being present that would trigger the statute, you just ignore the notice because the statute isn't triggered, and therefore then the mortgage is perfectly clear. It covers all the debt. We apply the common law rule. Bluegrass Savings Bank has senior priority over Community Bank.
Mr. Davidson, you may sum up.
Yes, thank you for your time. I appreciate your questions.
Rebuttal.
May it please the court. If the first mortgagee wants to make additional loans and secure it by that same property, it can simply file an amendment to the mortgage that increases the cap. That is done frequently. It can also choose to file another mortgage if it predates the subsequent recorded mortgage. 2, 3, 4, 5 mortgages could have been filed, no problem. Mr. Davidson does make one incorrect statement. The affidavit filed by Mr. Beck, who's the president of Bluegrass, stated that there was one note extended by Bluegrass to Mr. Stecker, it being note 3, that post-stated the Community Bank and Trust Co. mortgage. So this fact, as alleged, that all of these notes, all of this credit was extended before Community Bank and Trust Co. recorded its mortgage is not in fact correct. And that note was included as part of the $600,000. Also a note was included that predated the Bluegrass mortgage, and an additional, I think, 9 other notes. Each of those notes has a purpose provision. The note at issue, the $148,000 note, was to purchase a farm, and it stated under the purpose section of the loan is for that purpose. The other notes reference agricultural expenses, other types of expenses other than purchasing the farm. So it's not the same kind of transaction. It's different debt extended or different credit extended by Bluegrass for different purposes. I don't think that you have to strain the interpretation of 654.12a beyond exactly what it says, and there's a bazillion cases from this court that say the plain reading should be given to a statute that's clear and unambiguous. This statute is clear and unambiguous. It says exactly what it says. The dragnet provision can pull in other debt as long as the amount of that secured indebtedness does not exceed the cap provided in the mortgage, a cap which could be changed at any time between the mortgagee and the mortgagor.
So if you look at the plain language in a case where the senior lien holder doesn't have actual knowledge of a junior lien, or there isn't a junior lien at the time, what work does this language in the statutes do where it says the senior lien holder has priority, quote, even though the holder of the prior recorded mortgage has actual notice of indebtedness under a subsequently recorded or filed lien? What work does that language do where there's no actual notice?
It cleans up the common law exception, if you will, to 642.12a. It says that notice is now irrelevant. It's what you put in your mortgage that people can rely upon. It's recorded. Other lenders can see it. And those other lenders have the right to rely upon your cap as the amount of secured indebtedness ascribed to that particular parcel of land contained in the mortgage.
Statute then was intended to protect junior lien holders rather than senior lien holders who advance funds with actual knowledge of junior liens.
I think it protects both because it does give that first mortgagee the right to have the original note paid down to $1, but to pull in, using the dragnet provisions contained in this mortgage, other debt up to the full amount of the cap. So it gives both parties certainty as to what dollar amount is secured by that mortgage.
Mr. Davidson argued that the statute is needed to trigger. It was only there to trigger in case somebody would come along, such as your client's bank later on. Do you disagree with that?
I disagree that it is supposed to trigger some form of constructive notice inquiry on behalf of the junior mortgagee. I believe they have the right to rely upon that cap as representing the amount of the secured debt secured by that particular mortgage on that particular piece of real estate.
Mr. Terpstra, you may sum up.
Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.